It's what I would call a hot topic at the moment. The act was passed by Congress under President Biden. So if the Pregnant Workers Fairness Act is no longer valid, then the employer can more easily say no to an accommodation because she has suffered a prior miscarriage and couldn't lift heavy objects, and Amazon did not give her the accommodation.
Annisley, thank you so much for joining me today. Today, we're going to discuss the Pregnant Workers Fairness Act. I know there's been some recent new developments, and there's been a lot of news about the government rolling back protections for pregnant workers.
Sure, happy to discuss this topic. Thank you for having me on. It's what I would call a hot topic at the moment. So let's break it down before I actually answer that question. So what is the Pregnant Workers Fairness Act? This is a fairly new law that came into place in 2022. Before that, if someone is pregnant, the protections were under Title VII, under the Pregnancy Discrimination Act, or if there were disabilities related to the pregnancy, like complications from pregnancy, for example, medical issues that would constitute a disability, then the Americans with Disabilities Act would apply. The Pregnant Workers Fairness Act was enacted to fill the gap between those two. So one act, Title VII, deals with discrimination. The other one, Americans with Disabilities Act, deals with a disability. The Pregnant Workers Fairness Act actually makes it easier for pregnant women to get protections and accommodations. They don't have to establish that an issue they're having related to pregnancy, for example, is an actual disability to be able to get an accommodation from the employer. So there's been a lot of news about this because the act was passed by Congress under President Biden. Then once the Trump administration took over, there's been a lot of changes at the federal agency, the Equal Employment Opportunity Commission, the EEOC, which is the agency that then expands on the act. So Congress enacts the law, and then the EEOC sets rules that are followed on the law and actually enforces it as well. So that employees have to go to the EEOC first before they can proceed in court. So now with the change in administration, they are looking to, the new head of the EEOC is looking to cut back on some of the protections that were offered under, or that are still offered under the Pregnant Workers Fairness Act. And I say still because it's called the final rule, the set of regulations that come out, that hasn't been released yet for 2026. So we will know more when that happens. But there is a lot of talk about this because the suspicion is they're going to be very limited when the new rule is released.
What is it specifically that could change? What kind of protections might pregnant workers lose?
So, for example, last year in 2025, so the under the current rules, the elective abortion was included, okay, by the EEOC under the Biden administration. Well, last year, a federal court already said, no, that's too much. An elective abortion should not be included. The EEOC surpassed its ability to implement this rule. That is too much. Congress did not have this in mind when it enacted the act. We're not going to allow it. So we are looking for clarity on that when the new rule comes out. And given the change in administration, it is likely that things like, for example, accommodations related to an abortion will not be included as a protection under the act.
If I'm pregnant right now and I need an accommodation at work, am I still protected?
The answer is yes. So the Pregnant Workers Fairness Act, it's still in place. The law is active, you are protected. So if your employer says, for example, if you need a break because you're pregnant and you're on your feet and you're working at a restaurant and it's too much for you and you need a break, that is one of the things that's covered under the act. If the employer says no, you have a potential claim and you can go to the EEOC and file a charge. So as of right now, you are covered.
Can my employer force me to take unpaid leave instead of just letting me sit down or, give me lighter duties?
So that is a very good question. The short answer is likely no. the employer, under the law, the way it stands right now, the employer should be able to accommodate that request, because this law does not require, the burden is a lot lighter on the employee, right? It makes it harder for the employer to say no to the accommodation. So generally, employers can easily accommodate something like, sitting down or taking a break because you need it. So if they say no, that's a problem. If they say, for example, if you report to your employer, I'm pregnant, and they say, oh, I'm not dealing with this, take leave, right? That's also a problem.
Does Florida have its own protections, or are Miami workers relying on federal law completely?
The answer to that question is a partial yes. So, Florida as a state does not have the equivalent of like the Pregnant Workers Fairness Act. What Florida has is an equivalent to what Title VII, the federal law, and the Americans with Disabilities Act would provide, which is called the Florida Civil Rights Act. And that deals with the limitations of discrimination, like I explained earlier, or a disability, a medical condition that's considered a disability relating to pregnancy or pregnancy complications. That is different from the accommodations that are very broad at the moment under the Pregnant Workers Fairness Act. There is no state law equivalent to that act.
What kind of protections would Miami workers lose specifically should that act be overturned?
So it would be a lot more difficult to obtain what I will call kind of easier accommodations. For example, the Pregnant Workers Fairness Act does not require the accommodation, does not require the employee to be able to perform the essential functions of a job, which is a critical requirement under the federal law, the Americans with Disabilities Act. So if the Pregnant Workers Fairness Act is no longer valid, then the employer can more easily say no to an accommodation. So that's the potential impact.
If I work in a Miami restaurant, hotel, or store, how would this affect me specifically?
So right now, if you work in the hospitality industry, which is very large in Miami, it's a lot easier under the current law to obtain an accommodation. Like, for example, taking breaks, asking to not be on your feet all the time. Without the Pregnant Workers Fairness Act, it's going to be a lot more difficult, because if a pregnant employee asks to not be on her feet all the time, or requesting more breaks, there's really no law that protects that employee outside of the Pregnant Workers Fairness Act, right? Because it's not potentially, it depends. So if the pregnant worker asks for this accommodation and the accommodation is given to non-pregnant employees, then it's potential pregnancy discrimination, right? Potentially. If not, if the employer says no to everyone, it's very hard for the employee to have a potential claim, because there isn't really a specific protection under the law outside of the Pregnant Workers Fairness Act that will cover this situation. So it would be significantly harder.
Right now, if I'm pregnant and worried about my rights at work, what should I be doing?
So the most important thing is you put everything in writing. Right. Keeping a paper trail of everything is critical in the event you need it for litigation or any EEOC charge down the road. So, number one, if you're going to request an accommodation, for example, more breaks or whatever the accommodation is, put it in writing, whether that's a text message, whether that's an email, that's fine. It's just in writing is best. If the employer says no to it, ask the employer why, right? And put it in writing. So, for example, if you work at a restaurant and you send your manager a text message or a WhatsApp message saying, hey, listen, I'm pregnant, I have a lot of nausea, I need to take more breaks, right? And the manager then sees you at the restaurant and says, hey, no, 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 you're not taking more breaks, we're not doing it. The response is not in writing. We want it in writing for the future. So, what the employee should do is write back and say, hey, just to confirm our discussion earlier, you said no to the accommodation. Can you please explain why? And that way you're putting the employer on the spot in terms of a reason why. And they're probably more likely at that point, if they get pushback, to give you the accommodation. But if they do not, then we have that in writing, which is very helpful. In addition, if you find that after you requested the accommodation, you start to be treated differently by the employer, like you get worse shifts, for example, or more time off, or a demotion, or you're ultimately terminated, all of that could lead to a potential retaliation claim. So if you notice any change in treatment, the next step should be to complain to the employer and say, if this is legitimate, of course, you're giving me worse shifts, for example, and I think you're doing that because I asked for an accommodation and you retaliated against me. Because then that gives you, the employee, a potential claim down the road for retaliation if you are terminated.
Is this something that happens in large companies, or are they more willing to accommodate people, or is this something that usually happens in small businesses?
So I see it all over the map, and I'll tell you why. So it's very, very common in small businesses because small businesses a lot of times think anything goes, and they can get away with anything, right? At larger companies, it does happen, and this is why. A lot of times there's a disconnect between upper management and the local folks. So there's been an example about an Amazon warehouse worker. I mean, Amazon is a huge company with very strict procedures, and I'm sure they do regular trainings for their human resources people. And there's a charge with the EEOC right now from an employee who worked at a warehouse and needed an accommodation because she was pregnant with a high risk pregnancy because she had suffered a prior miscarriage and couldn't lift heavy objects, and Amazon did not give her the accommodation, and she was wheeled out of the warehouse to the hospital. And you would not expect that from a large employer such as Amazon. But a lot of times if the manager if the people on the ground at that warehouse have no idea what the law provides, and this is a fairly new law, right? 2022 hasn't been that long. If they're not educated on it, so they don't know what they're doing, right? And that's how you see violations with large employers oftentimes.
What do you think the chances are of this actually getting overturned? Are you following this?
We are following it very closely. So we don't think the law is actually going to be overturned as is because it was passed by Congress. What's more likely to happen is the rules from the EEOC, which expand on the law and its application, those are probably going to be narrowed so that there will be fewer protections for pregnant workers.